Okay, so that wraps up fraud and misrepresentation. Always remember intent. That's the main difference. Now let's get to the other really big section of this unit that you're gonna need to know for the exam, and that is negligence. So 5 elements of negligence. You have duty, breach of duty, causation. Alternate name is the but-for test. You have proximate cause. Alternate name, foreseeability. And, damages. Okay. So you need these 5 elements to establish negligence. Let's talk about the case that we went over to help us learn about negligence. And this is Palsgraf versus Long Island Railroad. This is a really famous case in tort law. Okay, so duty, breach of duty. That's pretty self-explanatory. Let's talk about causation and proximate cause. So you'll remember in the brief that we went over, Justice Cardozo, who later became a Supreme Court justice, he is talking about proximate cause and the foreseeability of the damages, okay? So he's saying that your duty of care is only to foreseeable plaintiffs. Okay, that's called the zone of danger, and since it was unreasonable to think that the chain of events that happened could have happened is so unlikely, we can't really hold the railroad liable for Mrs. Palsgraf's injuries, okay? Yeah, not a reasonable foreseeable consequence. Now, on the opposing side, Justice Andrews, he said that a duty to one is a duty to all, right? And so he's talking about the but-for test. But had it not been for the employee helping the gentleman on the train, Mrs. Palsgraf never would have been injured. The problem is where does it end? We could pick an endless line of liability and chain of events that were uninterrupted that led to these injuries being caused. So that's why Justice Cardozo is playing proximate cause and foreseeability to help limit the scope of causation, right? And then damages, injuries, is the last one. So that's a big chunk of this next exam, which you'll need to know. Let's talk about the 3 defenses to negligence, okay? So you have contributory, look at my notes, oh yeah, comparative, and assumption of risk. Okay, living here in Hawaii, I don't think we need to go over any more of assumption of risk. We've talked about all the inherently dangerous activities we do out here, having fun. Let's talk about contributory and comparative. You either live in a state that is contributory or comparative negligence, okay? You do not have both. Comparative, you are comparing the amount of negligence that the parties have, okay? For example, let's use round basic numbers. I'm involved in a traffic accident with Cole, okay? And they find that I'm 20% at fault for the traffic accident, okay? Maybe I'm supposed to be wearing glasses and I'm not that day. But Cole ran the red light. Okay, so they're gonna assign me a bit of the liability. And say the case is for, say, $10,000. I can only then collect 80% of the $10,000 or $8,000, okay? That's comparative negligence. We're comparing. Contributory means if you contribute or add to the negligent in any way, you're not able to then sue for damages, okay? And so that's why you can only be in a state that is either contributor or negligence, one or the other. Okay, questions about negligence, either the elements or the defenses? Okay, let's move on. Okay, you're gonna get a question on warrantless search and seizure pursuant to the current Fourth Amendment law. Okay, so the Fourth Amendment has to do with search and seizure by the government. Now there are several exceptions to the Fourth Amendment as it relates to search and seizure. Hot pursuit, meaning if law enforcement is pursuing a suspect who runs into a home or building, the police do not have to stop and then go get a warrant. They're allowed to follow them into the building. Any evidence that they would come upon during that would be usable in court, okay? That's hot pursuit. Another one would be retrieving evidence or say records, for example, from a burning building, okay? You're allowed to enter to retrieve or save evidence from being destroyed. And then the last one is that you'll need to know for the exam is plain view. Also includes plain smell. Meaning, if I'm a law enforcement, a police officer, I don't need a warrant if I see illegal material. Okay, if I pull you over and you have drugs in your car, I don't need to stop and get a warrant. It's plain view, okay, I've seen it, right? Same with, I believe you'll come upon a question on if police can search a dorm room if they were to smell, say, marijuana, which is still illegal recreationally here in Hawaii. They would be able to do that because plain view, plain smell. Those are going to be the exceptions to the Fourth Amendment that you'll need to know. Okay, let's talk about our favorite subject, which is businesses. This is a business law class after all. All right, so you're going to see this great question, and I just absolutely love it. You're this great business mogul, and you have a sole proprietorship, a limited liability company. You're the general partner in a general partnership. You're a limited partner in a limited partnership. And you're the stockholder of a corporation. Now, you're this great business mogul, but unfortunately all these companies have turned belly up, and creditors would like to recover from these businesses. You'll need to know which one of these businesses are you liable for, or which ones could a creditor come after you personally, okay? Sole proprietorship and a general partner in a general partnership, okay? Those are the type of business forms where you're going to be personally liable. The other ones, remember, the LL, limited, that's the corporate veil or what protects you from having your personal assets being exposed, okay? So limited corporation, limited partnership, and obviously a shareholder or an owner in a corporation, you're going to be protected. So you'll need to know that. Other things related to this is about the corporate veil. So the corporate veil is the limited liability protection from you and the creditors. So you'll need to know about what kind of behavior could allow creditors to pierce the corporate veil and come after you personally and expose your assets. Two things that you'll need to know on this exam that's coming up. Commingling funds, your personal funds with your business funds. Okay, you cannot treat your business like a piggy bank. And two is not having an annual shareholders meeting to elect a board of directors. Okay, so those two things are going to allow creditors to pierce the corporate veil. Remember, if you're a corporation or you want limited liability, you have to act like a corporation. Okay? Otherwise, you lose that. All right. Let's move on then. Okay, you're gonna see or need to know what kind of cases will get your case tried in a federal court. The main overall thing to remember is it needs to involve the federal government in some way to be in a federal court. Let's talk about 3 specific ways, okay? If it involves a government organization or the military, for example, your car gets hit by a military convoy coming from Schofield Army Base, right? You could sue in federal court. Another one is called diversity of citizenship. Okay, I'm from Colorado, and I decide I'm going to sue Brooke, who is from California, right? Obviously, we both want it in our own state's court system, so the jury is biased towards us, and so that's why for diversity of citizenship, you can have your case in federal court instead. And then you can also, if you're suing based on a federal law, okay, that will also allow your case to be heard in a federal court system. So, for example, you're suing Homeland Security for violating your constitutional rights, right? Some policy that they've enacted you feel violates your rights. You could sue in a federal court. So those are going to be what you'll need to know for the upcoming exam. Questions about any of that? Perfect. Okay, so the first case that you'll need to know is Harley-Davidson versus Grottinelli, okay? This case is about whether you can copyright a generic term. If you'll remember, Grottinelli wanted to keep their copyright on the term hog because we associate hog with large Harley-esque motorcycles. The problem is that Harley had stopped using that, and it had fallen into a generic term. I can't go copyright the term, cow. I mean, that's okay. That would be dumb. So the question asks that you'll need to know is, it's asked that, or it makes the statement that the court ruled that you could copyright a generic term as long as you could prove that your company was associated and identified by this term, which is false. Because even if people associate your company with it, that's not enough to prove mental association. The next case that you'll need to know is on scope of employment. So this is the Lange versus Nabisco case. So it's the case about the store owner and the employee of Nabisco who fought over the package of Oreos on the shelf. So the statement that you'll see is that the employer is liable for an assault by the employee if the attack is related to the duties of the employee as it relates to time and space. And that is true. So if you're doing the master's duty, right, that's scope of employment. In this case, the employee was doing work for Nabisco. So Nabisco is liable for their employee's actions. The next case questions that same idea. It's Faberty versus McDonald's. So again, we're talking scope of employment, but a little bit different here. So this is the case. You had the 18-year-old working for McDonald's, but he's a senior in high school, works a double shift, and then volunteers to clean the restaurant at night, drives home, gets in an accident, dies and injures another driver. So the statement is, that you'll need to know, is once an employee has left the business premises, the employee is no longer in the business's scope of employment. And the business cannot be held liable for the employee's actions. So this is false, right? Because even though he had left the physical location of McDonald's, it doesn't mean that his duties at work didn't affect him after work, causing him to get into the accident. And the next case is maybe Brother Gibson's favorite. It's Mosley versus Secret Catalog. Oh yeah. Okay. The courts. So here's the statement. The court said that mental association will not alone prove disillusion of famous trademarks. The example being Utah using the phrase greatest snow on earth on their license plate. That's a play off the trademarked term greatest show on earth, using greatest showman. Yeah, so just because Victor's little secret does make us associate it with Victoria's little secret, it doesn't take away from what Victoria's secret is. And certainly people walking into the store can tell the difference pretty much right away.
So this is true?
That's true.
Yeah, that is true.